Hi everyone. My name is Ramani. Some of you may have met you as I'm taking some lectures at board. So the purpose of this presentation is to give a summary of your week one lecture. There may be some of you have enrolled late, and some of you have missed your lecture. And for to help you guys for your studies, so I'm doing this record. I'm trying to do one or two recording to cover the chapter one, but this is going to be a summary. So you need to go through your other material, the textbook and the study guide and the PowerPoint on Moodle to help your studies. In week one, we discussed the Australian legal system. In this topic, we are trying to give an overview and understanding about the Australian legal system, as we are going to deal with a number of topics which are practically applied in Australian legal system. So mainly we will focus on the British settlement in Australia, the rights, land rights, and the recognitions of Aboriginal peoples under the Australian Constitution, and the uh, sources of laws, separation of power, federal system, and judicial precedent. Uh, so, firstly, we will see how British came and settled in Australia. In late 1700, British wanted to have a place to dump their convicted criminals, so that they lost the United States as they have declared their independence, and they needed to have a separate place to send their convicted criminals. So then they decided that Australia is the best place as it is an island. Geographically, it was important, and they declared Australia as their own land, and Australia became a colony of United Kingdom in 1788. At this, we call this is a settlement because there were no any battle or any agreement between the original landowners or the people who lived at the time in this country. That is the Aboriginal and Torres Islander people. Uh, the British used a concept that comes in international law. We call it terra nullius. That means no man's land. In this concept, it says if there is no inhabitant in any land, and uh, whoever captured that land can declare as it's their own land. So, as a result of this settlement, the Aboriginal and the Torres Islander people lost their rights to their own land. And gradually, British brought about 160,000 convicted criminals to this land time to time, and they are the people who developed this country up to date and improve the infrastructure facilities. And gradually, they brought their legal system, their health, education, and all the other administrative system to this country. Uh, so that time, so we had colonies. However, the having colonies was not was challenging for few reasons, because we did not have much population, and there was the issue of the defense of the country, and there was no proper tax system to collect the taxes. So for that, they decided that it is better for Australia to go for a federal system where one main entity control the entire country, and there are other small entities which they have power to govern them as their own entities. This was proposed to the Imperial Parliament, which is in the British, and in 1900 it was approved and passed by the British Parliament, and then this proposal became as an Australian constitution, and it was applied in this land, started to applied in this land 1st of January in 1901. That was a historical date. So the same constitution still we are using with very few amendments. So the land rights that the Aboriginal people lost at the British settlement, it was recognized and reconsidered by the Australian legal system in 1999. 1893. This was as a result of Mabo and State of Queensland decision. So this case is in your textbook, as well as there are plenty of videos and there are movies in relation to this case. If you browse online, you would be able to find these materials and you can read them to improve your understanding about the case. So in this case, High Court of Australia decided that the terra nullius concept that applied by the British at the time they settled in Australia was misinterpreted. It was wrong. Actually, there were people who lived in this land. So um, this was not a land without any civilization nor any inhabitants. So the court held that we must consider the land rights of the Aboriginal people and we must accept it. And to recognize this court decision, a Commonwealth Parliament, there was a pressure for the political um, administration to pass a separate law to protect the Aboriginals' land rights. As a result of this pressure, the Commonwealth Parliament passed the Native Title Act 1993, which protect the land rights of Aboriginal and Torres Islander people in this country. So that was the early settlement and the federation. Under the federal structure, they created a central government and 6 states and 2 territories. So until now, these 6 states and 2 territories are governing and they are making their own laws which subjected to the constitution, and they are governing by themselves. That is a federal structure. Under the federal structure, they proposed the separation of power, the doctrine of separation of power under the Constitution. The separation of power means the separating the power of the government between 3 institutions. We call them as legislature, that is the parliament, executive, and the judiciary, that is the court system. The separation of power between these 3 entities is important for any democratic society. This recognizes the rights of the people because this is a democratic society. People's representative are representing them in the parliament, and the parliament's objective is to make laws. And the laws that has been passed by the parliament must be implemented or executed by the executive. And when there is any dispute about these laws, and the judiciary can involve with the interpretation of these laws. Those are the roles of these 3 organs. This has been clearly established and explained in the Constitution. When it comes to lawmaking power of the Parliament, so Parliament can make laws under the Constitution. There are separate lists for which Parliament is making which laws in which related to which subject area. Common, as now we are aware, according to the federal structure, there is a Commonwealth Parliament which is in Canberra. So Commonwealth Parliament can make laws, and there's a separate list where exclusive power that has been granted to this Parliament to make laws. And there are other parliaments in the states and territories. So these entities also can make laws. They have their own parliament. They can make laws under the concurrent list, where Commonwealth Parliament as well as a state parliament make laws. There can be an issue where 2 entities are making laws on same subject matter. There can be dispute. To avoid any dispute that may cause, Section 109 of the Constitution provide that if there is any discrepancies in the lawmaking under the concurrent list in the Constitution, that is a Section 51 of the Constitution, then Commonwealth law must be prevailed and that must be practiced by the people. So Constitution itself provides certain provisions to govern this federal structure. That is the role of the Parliament. When Parliament is making laws, there is a process. The Parliament has 2 houses. Our Parliament, the structure of our Parliament is the Westminster structure, that is similar to the British system. There are 2 houses. If a Parliament is making laws, the law must be passed by the majority of the 2 houses. Otherwise, it is not going to be acceptable proposal legislation. It is not sufficient. It would not become a law until the Governor General sign it or accept it. So this is where we can see there is no pure separation of power under the Australian Constitution. As I mentioned, having separation of power is a democratic process where people's rights have been protected. The rule of law has been protected where people are treated equally before the law. That is a concept of rule of law. However, according to our constitution, the powers of the parliament and the executive are overlapping, where Governor General has certain influence in the parliament and the lawmaking process, and the Governor General has authority to dissolve the parliament when there is no consent between the two houses to make laws in the parliament. So in that sense, we can say there is no pure separation of power. However, in practically, we are enjoying the separation of power under the administration of the government. That is because we have a good governance and good government practices. So that is how the parliament make laws. So we are going to, under this unit, we are going to learn some of the laws that has been passed by the parliament. And the judiciary involved in interpretation of laws. So when judges are interpreting laws, there are certain ways, there are certain rules that they must follow when they are interpreting the laws. There are few rules that has been mentioned in your textbook. For example, literal rule, the golden rule, and mischief rule. When judges are interpreting the laws, they must adhere to these rules and determine their decisions. In next video, I will try to explain judicial precedents and the hierarchy system of the courts. So thank you for listening. If you have any questions in relation to this topic, so you can use the question and answer forum which is in the Moodle, as well as you can ask questions from your lecturer, or you can ask questions from me, and our email addresses are available in the Moodle. Thank you.